So the first topic we're going to be dealing with is the general principle of criminal law. Now, this also is one of the basic things or principles that we need to know, and it will strengthen our understanding, and at the same time uh, the application of what we learn here to other things that will come later, which are actually the substantive part of the course. So the first point we have on our slide is that there is no crime without the law. Now, the law of Nigeria or our criminal jurisprudence makes it a must that for anything to amount to a crime, it must be stated in the law. And this particular principle is otherwise known as nullum crimen sine lege in Latin. Nullum crimen sine lege, meaning there is no crime without the law. So what it means, therefore, is that for anything to amount to a crime or for an individual to be punished for a particular crime, such individual must have gone contrary to a particular law which is in force at every point in time. So, therefore, this principle is central to our understanding on this particular line. So that's the first one, which says no crime without the law. The second one is of a similar leg that says no punishment without the law. Now, we will look at section 36(8) of the Constitution of the Federal Republic of Nigeria and some other judicial authority on this subject. It is one of our principles of criminal law in Nigeria that there is no punishment without the law. And if you take your mind back to our very first class, we did say that the law will usually provide for a crime and at the same time list the punishment that is attached to it. So, if a particular law provides for a crime and fails to provide for the penalty, the court of law or our judicial system does not permit us in any way to arbitrarily apportion a punishment to such a crime. So meaning that before anybody can be punished, it must be stated within the law that this individual will commit X offense before he can be punished. So that principle is very central to our criminal jurisprudence, and the Supreme Court, in the case of Okoro and State, made that expressly clear that punishment must conform strictly to that which is prescribed in the law, and anything outside that will amount to a nullity, so to speak. So to this end, this principle of criminal law is of great importance, and we need to also fix our mind on it. The third one is that there is no retroactive criminal law. What this means simply is that a law that is made is only applicable from the point of that law or of the enactment, meaning that you cannot make a law to take care of a crime that has